All right. Good morning. We're gonna go on the record. It's 9:41. I would like to call today's hearing to order. It's hearing involving South Coast Air Quality Management District versus the Southern California Gas Company, case number 137-82. And so before we go any further, we're going to take about a 10-minute break or recess, as it were, and come back on the record in order to review several documents and handle a few other matters that I would call administrivia. So we're off the record for 10 minutes. Good morning. We're back on the record. Back on the record at 9:53 a.m. Madam Clerk, out of curiosity, are there any individuals online interested in providing any evidentiary testimony or general public comment? Okay, let the record reflect that no one has their hand raised. And also let the record reflect that no one is before the hearing board seeking to provide evidentiary testimony on our general public comment. There are a host of exhibits that we will mark. First, before we do that, Mr. Pearman, I believe you had a statement.
As my Form 700 shows, I own stock in Semper, a tiny amount, which is the parent of Southern California Gas Company.
And he literally owns like penny stocks, just like a few coins, right?
Not like you.
Nothing too extravagant. Okay, so he's getting nothing out of this. All right. So there are several exhibits, petitioners exhibits, exhibit 1. But first, who's representing the?
Andrew Vogel from Southern California Gas Company,
Okay,
the petitioner.
representing the respondent?
Stacy Pruitt for the executive officer.
We rarely see Ms. Pruitt, so we're very happy that she's here with us today, all right? Okay, petitioner has a host of exhibits. Number 1 is, Exhibit 1 is revised Title 5 permit to operate. Number 2, satellite view facility. Exhibit 3, Rule 1100 compliance plan submission dated 3/14/25. Exhibit 4, Rule 1100 compliance plan approval dated. The other, Exhibit 3 is a submission dated 3/14/25. Exhibit 4 is Rule 1100 compliance plan approval dated 4/18/25. Exhibit 5 is a compressor area map. Exhibit 6 is the turbocharger diagram, and then the respondent's exhibit is proposed variance conditions. And I do believe that you'd like to make an opening statement and some corresponding remarks, Mr. Vogel.
Yes, thank you. Good morning again, hearing board members. My name is Andrew Vogel, and I'm the attorney for the petitioner, Southern California Gas Company, which I'll refer to sometimes as SoCal Gas for short. And we may be using petitioner and SoCal Gas interchangeably today. SoCal Gas is a public utility that transmits, stores, and distributes natural gas for customers, including over a dozen natural gas-fired power plants throughout Southern California. A key part of this distribution system is the Playa del Rey storage facility. Playa del Rey is used to store natural gas in an underground storage reservoir. Injecting gas into this reservoir for storage when gas demand is low and withdrawing gas for customers when demand is high helps manage demand fluctuations, protect customers from energy shortages, and provide energy security to the region. The facility has 3 internal combustion engines that drive 3 natural gas compressors. Playa del Rey is a Title V and reclaim facility, and as part of the reclaim sunset process, Playa del Rey's 3 engines must comply with a more stringent oxides of nitrogen, or NOx, emission limit of 11 parts per million under District Rule 1110.2. SoCal Gas submitted a permit to construct application to retrofit these 3 engines in order to meet this new emission limit in June 2021. The retrofitting involves installing selective catalytic reduction control, or SCR, equipment and a continuous emissions monitoring system, or SEMS. The district issued a permit for this work in May 2023, and the district later granted a 12-month extension of the permit, making the permit expiration date May 18th, 2025. SoCal Gas worked diligently on moving this retrofit project forward, but due to unforeseen circumstances that were beyond SoCal Gas's control, which you will hear more about from our witnesses, it became apparent that SoCal Gas would not be able to complete the project and meet the 11 ppm NOx emissions limit by the May 18th, 2025 deadline. Now, we realize that the board has before it multiple documents, specifically a variance petition that SoCal Gas filed on April 1st, a compliance plan that district staff issued a couple weeks later on April 18th, and the most recent document, a request by SoCal Gas on May 7th to amend its variance petition by seeking a variance from the compliance plan itself. But to be clear, after extensive discussions this week with district staff, we are withdrawing today our amendment to our variance petition that was filed last week, although we still plan to refer to Exhibits 3 and 4 to that amendment. So as a result today, SoCalGas is now seeking a variance only from the 11 ppm NOx limit under Rule 1110.2 and only through the end of February 2026, so that once the retrofitted engines are installed and operational, the approved compliance plan would then govern these 3 engines. If the board will permit, I'd like to step back for a moment and walk the board through how we got to where we are today and why our request has evolved over the past several weeks. Once SoCalGas determined in around October of last year that unforeseen circumstances beyond its control would leave it unable to meet the 11 ppm NOx emissions limit by the current May 18, 2025 deadline, SoCalGas promptly reached out to district staff in November of last year and then had discussions with district staff this past December and January about submitting a compliance plan. When district staff confirmed in January of this year that a compliance plan under Rule 1100 would be a viable option for SoCalGas, SoCalGas submitted that compliance plan on March 14th, which would extend SoCalGas's compliance deadline by 2 years to May of 2027. But since staff advised that it could take them up to 3 months to approve or reject the compliance plan that SoCalGas submitted, which would have put us past the May 18th compliance deadline, SoCalGas also submitted a variance petition to extend its compliance deadline to comply with the Rule 1110.2 NOx limit. District staff ultimately did approve the compliance plan on April 18th. And that approval includes a condition that requires SoCalGas to meet an interim 45 ppm NOx limit starting on the compliance plan's effective date of May 18th, 2025, just a few days from now. Right after SoCalGas received this approval, we explained to district staff that SoCalGas will be unable to meet this interim 45 ppm limit, and that is because SoCalGas will not have its SCR equipment installed by May 18th. So on May 7th, we filed a request to amend the variance petition by seeking relief from the compliance plan's 45 ppm interim limit. Since filing that request to amend the variance petition last week, we've had extensive and productive discussions with district staff and council. And as a result of those discussions, and now to bring the board back up to speed to today, SoCalGas is no longer seeking a variance from the approved compliance plan, and we are withdrawing today our variance petition amendment that requested this relief. Rather, just to reiterate, SoCalGas now respectfully requests a variance from the 11 ppm NOx limit under Rule 1100 D3, 1110.2 E10, and permit condition A195.5 of its permit to construct. And we're seeking that variance not for a full year from this month, but instead only through the end of February 2026, at which point the 3 engines will become subject to the approved compliance plan once the retrofitted engines are installed and operational. SoCalGas is confident that it can complete its retrofit of the 3 engines and complete compliance testing by December 31st. But keeping the approved compliance plan in place after December 31st will afford SoCalGas a little bit more time to test the engines once the retrofits are complete to make sure they can meet the 11 ppm NOx limit. We've discussed this updated request extensively with District Council, and I believe I can represent that we have a meeting of the minds on proposed conditions to the variance that SoCalGas is requesting. So turning to the merits of our variance petition, we have 3 witnesses here today who are prepared to testify and who will testify to facts supporting the required findings for a variance under Health and Safety Code Section 42352. We thank the hearing board for considering today's request, and we want to reiterate our gratitude to district staff for their responsiveness throughout this process.
Thank you, Ms. Pruitt.
Yes, the district received Southern California Gas Company's original petition for variance on April 2nd, 2025, and subsequently received an amended version on May 7th, 2025. Since the initial filing, district staff and representatives from SoCalGas have engaged in extensive discussions continuing through last night and most recently this morning. After careful and collaborative consideration, both the petitioner and the district are in agreement that the necessary findings can be made under the original petition for variance. Furthermore, adherence to the proposed conditions will place the petitioner on a clear path to compliance. To preempt any discussion suggesting that the compliance plan outlined in the amendment should be pursued, the district notes that the amendment does not represent a viable path to compliance. Specifically, the amendment requires that all 3 control devices be installed and operational by May 18th, which is just 3 days from now, and it's not feasible. As such, the amended plan does not satisfy the requirements of Rule 1100D. Accordingly, with respect to the original petition for variance now before the board, the district does not oppose its approval.
Okay, we just want to be clear now. You oppose the amended iteration.
Well, there is
So
no amendment. It's been.
We are withdrawing, so you have before you a May 7th amendment to the petition. We are
Okay.
withdrawing that.
Okay.
And now we're seeking a variance again from the Rule 1110.2, 11 ppm NOx limit only through the end of February 2026, at which point the approved compliance plan would then essentially kick in and govern.
Sounds like this could have been a consent item.
Sounds like.
All right, so I do believe there are witnesses on the respondent side as well. Ms. Pruitt?
Only if necessary, we would call Osiris Torres, who is a senior air quality engineer. But we don't plan on calling him unless absolutely
I believe
necessary.
we see, Mr. Torres is a star in this all-star cast. I believe we've seen you before, right?
Yes, I was back in October of last year for a different case.
Okay, I remember you vividly. All right.
I come with a strong team.
There we go. Okay, so why don't we have the individuals who will serve as witnesses to stand so we can administer the oath?
Just in case you.
Have you raised your right hand? All right, do you affirm that the testimony that you'll give in this matter today is the truth, the whole truth, and nothing but the truth? Yes. All right, let the record reflect that all have heard and received and accepted the oath. Thank you. All right, so Mr. Vogel, I will turn it over to you.
Okay, SoCal Gas would like to call its first witness, Daryl Johnson. Mr. Johnson, you're under oath, correct?
Yes.
Could you please state your name and spell it for the record?
Daryl Johnson, Darrelljohnson.
For whom are you employed and what is your position?
I'm employed by the Southern California Gas Company. My position is Senior Manager, Air and Climate Compliance Programs.
And how long have you held this position?
A little over a year.
What are your responsibilities in this position?
I manage 3 teams, an air team, a greenhouse gas climate team. Oh, sorry, thank you. And an air initiatives team. We have the responsibility of doing legislative and regulatory review, permit applications, greenhouse gas and air quality reporting, and air strategy.
And what did you do before your current position?
I was the manager of the air and greenhouse gas team for Southern California Gas Company.
I'd like to refer you to what's been marked as Exhibit 1, which should be in the binder there.
Yes,
Could you please describe Petitioner's Exhibit 1?
this is an permit to construct from South Coast Air Quality dated May 19th, 2023 for retrofit of 3 internal combustion engines for the facility.
And the permit to construct is dated May 19th, 2023, correct?
Yes,
And it states that it expires on May 18th, 2024, correct?
yes,
Did the district extend the permit before it expired on May 18th, 2024?
yes, the permit was extended to May 18th, 2026.
Okay. Is it 2026 or 2025?
Oh, I'm sorry, the 2024 was extended to May 18th, 2025. Thank you.
Sure. And that May 18th, 2025 date is the current expiration date, correct?
Yes, that's correct.
As SoCalGas's first witness, could you briefly describe the Playa del Rey facility as well as the equipment that are the subject of SoCalGas's variance request today?
Yes. The Playa del Rey facility is a natural gas underground storage facility that stores gas for use during high demand periods. It consists of 3 internal combustion engines that are used to compress natural gas into the underground storage field. The 3 pieces of equipment subject to the variance are natural gas compressors driven by internal combustion engines, device D14, D16, and D17.
Knowing that SoCalGas's next witness will be going into greater detail, could you describe briefly why SoCalGas needs to modify this equipment?
In order to meet the requirements of the Reclaim Sunset Rule 1110.2 requiring an 11 ppm NOx limit, we have to retrofit the equipment with selective catalytic reduction system.
And in general terms, knowing again that SoCalGas's next witness will go into greater detail, how is SoCalGas modifying the equipment?
SoCalGas is installing a selective catalytic reduction system and superchargers for each of the units to reduce and minimize NOx, and upgrading the electrical distribution system to accommodate increased power consumption.
Just to be clear, what are the district rules and the permit condition from which SoCalGas is seeking a variance?
Rule 1100, Rule 1110.2, and the permit condition A195.5.
And what do these rules and the permit condition require?
Rule 1100 sets forth an implementation schedule for compliance with the Rule 1110.2. And Rule 1110.2 outlines the NOx emission limit of 11 ppm for the stationary combustion engines. The permit to construct A195.5 of the compliance plan require compliance with Rule 1100, Rule 1110.2, and applies the 11 ppm NOx limit to the 3 engines.
I think you may have said that condition A195.5 of the compliance plan. I think you meant the permit to construct. Right?
Permit, yes. Thank you for the correction. Yes.
Now, SoCalGas will be in violation of these rules and this permit condition as of May 18th, 2025, correct?
Yes.
And how exactly would SoCalGas be in violation of the 11 ppm NOx limit?
Well, if SoCalGas cannot install the selected catalytic reduction by the deadline, then therefore it would not be able to meet the 11 ppm NOx limit.
And to your knowledge, SoCalGas cannot install that equipment by May 18th, 2025, correct?
That is correct.
Knowing that SoCalGas's next witness will go into greater detail, could you briefly describe or tell us when and how SoCalGas determined that it would not be in compliance with the 11 ppm NOx limit by the May 18, 2025 deadline?
Yes. In October of 2024, SoCalGas had several delays in equipment deliveries, and when it evaluated its implementation schedule and considered those delays, it realized it would not be able to meet the schedule.
When and how did SoCalGas inform the district that it will not be in compliance with the 11 ppm NOx limit by May 18, 2025?
In November of 2024, concerned about the inability to meet the schedule, we reached out to South Coast Air Quality Management District to request a meeting and discuss issues and a path forward.
When SoCalGas asked last year for a 12-month extension on its permit to construct, which was at that time expiring in May 2024, did SoCalGas update the district as to what was happening with the project and the equipment, and particularly the problems and delays you just mentioned?
Yes, our request for an additional 12 months was accompanied by a summary of the challenges that we experienced and projected in encountering, considering the update of the equipment to meet the 1100 conditions.
Okay. And when that was communicated, did the district have any particular questions or concerns?
None that I recall.
Did SoCalGas and district engineering staff meet on December 5, 2024 to discuss the reasons why SoCalGas would be unable to comply with the 11 ppm NOx limit by the May 18th, 2025 deadline?
Yes.
So that meeting was on December 5th, 2024. Who was there on behalf of the district engineering staff, and what was discussed?
You had Shannon Lee, Lee Chin, and Kristen Avalos from the district staff present during the December 5th meeting. And we discussed the compliance deadlines and discussed the potential for a extension to our permit to construct and the potential option for a compliance plan to pursue under Rule 1100 D5.
Mm-hmm. And you mentioned the compliance plan. Can you explain what a Rule 11 compliance plan is, as it was discussed at that meeting?
Well, the Rule 1100 compliance plan provides a path forward to comply with Rule 1110.2's 11 ppm NOx limit. And 1110.2, we discuss our inability to meet the 11 ppm NOx limit and the potential need for a permit to construct and the compliance plan.
Yeah.
Or the option for a compliance plan.
After this December 5th, 2024 meeting, when did the district engineering staff and SoCalGas have contact again regarding a Rule 1100 compliance plan, and what was discussed?
Well, we were contacted on January 16th of this year by the district via email, and they had reviewed internally whether there was an option for a compliance plan, and they said to us that the 1100 compliance plan was an option for the facility.
And did SoCalGas ultimately submit a Rule 1100 compliance plan to the district for its review and approval?
Yes, we submitted a compliance plan to the district on March 14th of this year.
I'd like to refer you to what's been marked as Exhibit 3 and is in your binder. Do you recognize Exhibit 3 as a copy of the compliance plan that SoCalGas submitted to the district on March 14th, 2025?
Yes, I do.
And after it received SoCalGas's compliance plan, did the district say when it would complete its review of it?
Yes, the district said that it was one of the first of its kind and it may take a little bit longer. So they estimated approximately 3 months to the review process.
And did the district ultimately approve SoCalGas's compliance plan?
Yes.
When was that?
The district approved the compliance plan on April 18th of this year. We received that compliance plan notification on April 24th of this year.
And if you could page over to what's been marked as Exhibit 4. Do you recognize Exhibit 4 as a copy of the approved compliance plan that SoCalGas received from the district?
Yes.
And this has an effective date of May 18th, 2025, correct?
Yes, it does.
The approved compliance plan was also accompanied by the district's separate written approval of an extension of the permit to construct expiration date, correct?
Yes, that deadline was extended to May 18th, 2026.
Did the district's approval of the compliance plan, Exhibit 3, also include conditions?
Yes.
And one of these conditions concerns the NOx emission limit for the facility's compressor engines, correct?
Yes, that's condition 3 on the second page.
And what does condition 3 require?
Condition 3 says, until permitted emission limit compliance is achieved, the subject compressor engines, devices D14, D16, and D17 will meet a NOx emission limit of 45 ppmv, corrected to 15% oxygen on a dry basis, averaged over a fixed interval of 3 hours. The emission limit will not apply during startup and shutdown.
Turning back to the district rules again and the permit to construct, just to confirm, SoCalGas will be in violation of the 11 ppm NOx emission limit under Rule 1100, Rule 1110.2, and PTC Condition A195.5 as of May 18th, 2025, correct?
Yes, that's correct.
And by the way, when I say PTC, you understand that means permit to construct.
I do.
Okay. Switching gears, according to Health and Safety Code Section 42402.1, a person who emits an air contaminant in violation of a district rule or a district permit is liable for a civil penalty of up to $25,000 per day. Will SoCalGas be liable for penalties of up to $25,000 a day if it's unable to comply with the 11 ppm NOx limit under Rules 1100 and 1110.2 and PTC Condition A 195.5?
Yes, it will.
And being liable for penalties of up to $25,000 a day, a compliance delay of, say, 40 days could amount to a $1 million penalty, correct?
Yes.
And SoCalGas must also pay excess emissions fees, right?
Yes.
So would imposition of these potential civil penalties on top of excess emissions fees constitute an arbitrary and unreasonable burden on SoCalGas?
It would. Yes.
And SoCalGas is therefore requesting that any excess emissions be quantified on a per ton basis rather than a per day basis, correct?
Yes.
Okay. And why is that?
Because a per day emission basis could apply to days when the equipment is actually not operating.
Okay. Kind of changing gears again here. If the facility were forced to close and cease operations, would that result in a reduction of air contaminants?
Not necessarily.
And why not?
Well, the facility plays an important role in addressing unexpected surges in energy demand. And if we were unable to operate during these peak demands, that may result in, power being used by less efficient or less clean methods, say if the grid were to go offline in that area. It also, if we're unable to inject gas into the storage field, it limits our capacity or ability to deliver gas if necessary during high demand.
Has SoCalGas estimated what the excess emissions would be during the variance period if a variance is granted?
Yes, we calculated excess emissions come from the previous operating year, assuming similar weather conditions and natural gas demand.
And could you walk us through a little further SoCalGas's calculations?
Yeah, so we took the monthly fuel use and multiplied it by emission factor to equal the pounds per month of emissions. And we used the calculation from Rule 2012, Appendix A, Chapter 3, to calculate the emissions. And because we have a permit limit of 225 parts per million, for our emissions, that equates to approximately 884 pounds or 884.2 pounds per million standard cubic feet of emissions. And we use that to calculate our emissions.
And the new lower limit of 11 ppm NOx would result in its own emissions factor, right?
Yeah, the 11 ppm would result in an equivalent emission factor of about 43.26 pounds per standard cubic feet. And the delta between the emissions associated with the 225 pounds or the 884 and the 11 pounds or the 43.26 is really how we determine the excess emissions.
So this is an excess emissions estimate, but would you consider this estimate to be high?
Yes, I would. And the reason being is that the estimate is derived from a default emission factor using the 225 parts per million when our actual emissions are less. And in fact, we've done source testing recently that shows that our actual emissions are in fact less.
How does SoCalGas plan to reduce these excess emissions during the variance period if a variance is granted?
So the facility doesn't have equipment that it could either operate less or not operate per se to mitigate emissions. But because the nature of the operations of the facility, it doesn't operate all the time. It only operates when needed. We would work to expeditiously install the selected catalytic reduction as soon as practicable.
Has SoCalGas discussed with the district its plan for mitigating excess emissions during a variance period?
Yes, we have.
And what has been the district's response?
Well, the district has proposed some slightly different emission factors for their calculation. Very close, the difference between 884 and 871. So, we would use the district's emission calculation until SIMS equipment is fully installed, operational, and tested. And then following that, we would use the lower emission limit of 42.59 and for the remainder of the variance.
So to recap, SoCalGas's plan for mitigating excess emissions during a potential variance period is to bring online as soon as possible each of the retrofitted engines as soon as the retrofitted engine has passed all its tests. Is that right?
Yes, that's correct.
If a variance is granted, how will SoCalGas quantify emissions from the equipment during the variance period?
We'll use our monthly fuel meter reads to calculate NOx emissions each month.
And will SoCalGas report these emissions to the district?
Yes, and we currently report those emissions to the district now monthly.
Okay. And has SoCalGas discussed the manner of quantifying emissions during a variance period with the district?
Yes, we have.
Just a couple last questions here. To your knowledge, has SoCalGas reviewed the variance conditions proposed by the district?
Yes, we have.
And to your knowledge, SoCalGas agrees to them?
Yes, we do.
Thank you, Mr. Johnson. I have no further questions. Counsel, your witness.
Ms. Pruitt on cross. Members of the hearing board. Ms. Verdugo-Peralta.
Thank you, Mr. Chair. So in essence, this facility is like a peaker plant and it's only being called upon when the demand is high. Is that correct?
It's not so much a peaker plant. It's a storage facility that injects gas into underground infrastructure, but that gas is used from that infrastructure when demand is high.
Okay, and what is your normal, let's say, season when the demand is the highest?
Well, it depends on temperature, right? And so if it's a hot summer, you might have air conditions. A cold winter, you might have heating.
So you're providing the natural gas not only to the community, but also to the generating facilities?
That's correct. It's logistically located to address the needs of the energy generation facilities.
Okay, thank you.
Any additional questions, Mr. Bella-Capellan?
Yes, I do. Morning, Mr. Johnson.
Good morning, sir.
Trying to understand what's going on here. Let me go to Exhibit 4 on the compliance plan. And I did look at your submittal for the compliance plan. It was very detailed. The plans coming, and as you mentioned, the compliance plan is a path forward to compliance, correct?
That's correct.
So that outlines how you plan to come in compliance
correct.
as per the rule. So you did indicate you need, in your initial submittal, when did you expect to come into compliance with the rule?
Well, I mean, into the delays, we thought we were going to come into compliance with the rule this May 18th, right?
Right.
And with subsequent delays, we realized that we weren't. We even then thought we might be able to get a unit or two online, but that didn't come to fruition either.
Okay. So so the compliance plan offers a path forward, and when the compliance plan was issued, and in Exhibit 4, and I'll refer to that, and there were several conditions. And I think you read condition number 3 that says you have an interim limit of 45 ppm.
That's correct.
But, and your revised petition, you're withdrawing. So you know, but you still want to keep the compliance plan date, correct?
That is also correct, yes.
So then you will also pay the mitigation fee?
Yes,
And how much is that fee?
$100,000.
100,000, okay. Now, can you look at condition number 6 of the compliance plan?
Yes.
Yeah, condition number 6 offers you the ability to request basically a revised compliance plan and ask for a further extension for 12 months, correct?
That is correct. And that's also one of the reasons why the compliance plan is important, because the 1100 series compliance plan provides the provision for that request.
Right. And so when you submitted the compliance plan, clearly, I think you indicated did you indicate that the 45 ppm is not an option, correct? You could not meet the interim 45 ppm, correct?
Well, we indicated that we would not have the selected catalytic reduction installed, or we did not believe we could have a selected catalytic reduction installed. We didn't discuss the 45 ppm until after we received the compliance plan.
So I'm a little confused. Why would the district issue a 45 ppm, knowing the moment they issued it, that you will be out of compliance? On a forward on a compliance plan, you'll be out of compliance with the 45 ppm. Did you discuss that with the agency?
We did not discuss it until after we received it. What we discussed was whether there was an option for a compliance plan in December during our December 5th meeting. And we, in January, we received that after deliberation, that there was an option for a compliance plan path. So at that time, we just waited to receive the compliance plan.
Did you discuss filing a revised compliance plan right now?
Not to my knowledge.
Not to your knowledge. Do you see a provision in the rule that allows you to submit a revised compliance plan?
The rule does have a provision for a revised compliance plan, but that revision is based on the inability to meet the emission limit, right? So if you during the compliance period, right, once you've established your control, if you're unable to meet the compliance plan, my understanding is that you could apply for a revision to the compliance plan. Say, for example, if you're required to meet whether it be 11 ppm or 45, and you are able to demonstrate that the equipment is incapable of meeting those ppm limits, then that revision would allow you to not only the district to consider a different ppm level.
But you indicated actually in your compliance plan, the way I read it, you will not meet it, until you have all the SCR and the compressor, electrification in place, correct?
We will not need, I need a clarification of what you're asking we won't need. I apologize.
Okay. In your compliance plan, if you look at the compliance plan,
Yes.
I think I believe it is very well detailed and articulated how you would come in compliance with the 11 ppm limit.
Yes.
So until at that time, you will be out of violation. Forget the number, whatever it is, 225. You'll be out of compliance with the 11 ppm limit.
That's correct.
All right. So so when the compliance plan was issued with a 45 ppm limit, clearly that would have put you out of compliance right away. And then you have a provision, and let me back up a little bit. Were you involved in this rulemaking? Were you involved in the rulemaking process?
I was.
Okay. So I do believe, and I remember reading it too, there was a provision in the rule and in the staff report that actually talked about if you go with the compliance plan, you don't actually, indirectly says you don't have to come to the hearing board. Did you hear anything about that during the?
Yeah, and I'd like to sustain your objection.
Okay. Okay, let me rephrase that then. Does the rule allow you the provision to come into compliance with the limits without having to come to the hearing board, to your knowledge? Or do you have to have this variance?
Well, I would say that the rule potentially gives that provision, but once we receive the compliance plan, we have to comply with the compliance plan. So that is the reason, in addition to the 11 our ability to comply with the 11 ppm, we're unable to comply with condition 3 of the compliance plan. So those two considerations, if we were able to comply with the compliance plan, we would not come to the hearing board.
Correct. And so what I'm hearing from you, and maybe I'm misunderstanding it, you don't think that the 45 ppm limit applies until you install the control and you're unable to meet the 45 ppm, and then for whatever reason, and then you'll have to reapply, do the modification to ask for an extension. Is that what is the attorney standing?
Could I just clarify?
Objection relevance, because this is not the route that they're taking. They're going with the original variance. And the compliance plan will not be an issue. It may not be an issue if they come within the 11 ppm. So I would object that this is not relevant at this time.
Sustained. Mr. Vogel, your objection?
I was just going to add on that the specific relief we're seeking today is a variance from the 11 ppm NOx limit only through February 2026, at which point we would have the compliance plan essentially kick in.
And I'll sustain your objection as well, Mr. Balakapalan.
Okay, so and you say, attorney mentioned that will kick in. What's your understanding of that, Mr. Johnson?
That we will comply with the conditions in the compliance plan, and condition 3 would be applicable.
Okay, okay, the 45 ppm.
That's correct.
But you expect by to come into compliance with 11 ppm, right? By February 2026.
The reason for the compliance plan is that, we need some testing to be able to come in compliance with the 11 ppm. We do believe that we will comply with the 45 ppm once the selected catalytic reduction is in place, and use the period allotted to tune and adjust so that we can ultimately come into compliance with the 11 ppm.
Okay. So when a compliance plan is issued, such as this, is it overriding some of the permit conditions, basically?
Objection relevance.
Because
I'll
relief,
sustain the objection
Okay.
and ask that Mr. Balakapalan provide a measure of relevance. Why is that germane?
well, this compliance plan is introduced as an exhibit, and you want this compliance plan to be still valid, correct?
Yes,
After the variance ends.
But not
yes.
Okay. And that's why I'm having a little problem with, because anyway, okay, let me maybe I'm reading too much. Let me look at the proposed condition. Let's look at the condition to calculate the excess emissions. And it's specifically condition 7. I heard you say why it should be calculated on per ton basis rather than a per day basis. And can you explain again what exactly is that? What does that mean?
Well, so the penalty is really related to the potential for a penalty on a per day basis and a calculation that would be necessary for a per day penalty.
Right.
And because the equipment is only operated as necessary, that might be punitive. And we believe that a per ton basis might, provide a less conservative approach to estimating excess emissions.
Okay, but you pay based on the per day basis.
We were requesting to pay based on a tonnage basis.
I know, but the excess emission fee there's a minimum excess emission fee you have to pay per day, the day you're operating out of compliance. You're aware of that, right?
Yes.
So you will pay on every day that you operate and that you're not meeting those limits.
Right. So if we were,
Okay, so I understand now because you are operating it intermittently, you will average the month and then average over the number of operating days and calculate.
that's correct.
And so my understanding is every day that you operate and you're not meeting the 11 ppm, it is an excess emission day.
From a penalty standpoint.
No, not penalty from the rule, from the excess emission fee standpoint, 306.
Right.
Okay, all right. So in addition to the excess emission fee, you pay the mitigation fee also.
That's correct.
Yeah, they'll pay all applicable fees.
Okay.
Right.
We have the payment ready today
Okay.
for the 100,000.
Mr. Chair,
Mr. Dugo-Peralta?
I'm concerned we're going down a rabbit hole here because it's obvious that if they're not going to be operating daily and they are intermittent due to the fact that it's for storage purposes, it makes sense that it would be tonnage versus per day because they're not operating every day.
I know that's
So-
what I just said.
Well,
So
they also said that in their statement, in their opening
Right,
statement.
that was
So
said in the open.
I just think we're
good.
duplicating what was already said, and we're going to go down a rabbit hole here that I don't think we need to do.
I did not understand the language in the condition, but I do now.
So let me ask you this, are there any pressing questions from members of the hearing board, or can we move to closing remarks? Because I mean, it's pretty cut and dry.
I'm sorry, we have 2 more witnesses, but I'm sorry.
Are there any more questions from members of the hearing board?
Not for Mr. Johnson. no.
Okay, but can we expedite to closing?
We have several.
Sir, hold on
oh,
one second,
I'm sorry.
sir.
I
Relax.
thought it was
No.
addressed to me, sorry.
Are we comfortable with proceeding forward, or do we want to hear more witnesses? Because I mean, it's pretty cut and dry. We can be here another 30 minutes to an hour hearing additional witnesses, or do we want to go ahead and expedite to closing? Doesn't appear to be any disagreement with respect to the conditions as placed before the board.
I think, in my opinion, based on my experience with the utilities, that once they are stating everything here in the conditions that both parties agreed to, I think that's where we're at. And it's a done deal as far as understanding why they need the time and why they are going to calculate per ton versus per day. So I'm okay with going forward. And since everybody agrees on this, and as was stated earlier, it could have been on consent. I think we're okay. Not, if we don't need to listen to a duplication of what we already have heard by the other witnesses.
And read.
I would like to know, maybe not even, just a summary of what the witness was going to talk about.
Okay, is there a summary perhaps of what the witness was gonna, what were you gonna question the witness on, Mr. Vogel?
Certainly, we were going to question Ms. Pacheco about the reasons outside of SoCalGas's control, why, in the circumstances outside of SoCalGas's control, why the 11 ppm NOx limit can't be met by the current expiration date.
So members of the board, I mean, is that we've read it, so do we want to hear her testify to it? Mr. Penman, your thoughts?
On that point, nothing additional is needed by
All
my
right.
standards.
Sure.
Right.
Right.
She would have testified to several of the items under Health and Safety 42352.
We've read it. All right, so we're gonna move to closing.
Okay, thank you.
Mr. Vogel?
So I'd like to briefly summarize SoCalGas's evidence and testimony in terms of each of the findings required for granting a variance under Health and Safety Code Section 42352. First, the board has before it Mr. Johnson's testimony that without a variance, the 3 compressor engines at Playa del Rey will be in violation of District Rule 1100 and Rule 1110.2 and Condition A 195.5 of its permit to construct by not being able to meet the 11 ppm NOx limit by May 18th of this year due to the NOx controls on each engine not being installed by that date. Second, the district has before it our evidence that SoCalGas's inability to meet this 11 ppm NOx limit by May 18th, 2025 was caused by conditions beyond SoCalGas's reasonable control, including unforeseen problems with the use of turbochargers arising from a calculation error by the original equipment manufacturer, the need to replace turbochargers with superchargers, the increase in power requirements for the superchargers, and related circumstances outside of SoCalGas's control. Third, Mr. Johnson has testified, and the board has evidence before it, that requiring compliance would result in an arbitrary or unreasonable taking of property. Specifically, noncompliance with the reduced NOx limits could subject SoCalGas to penalties of up to $25,000 per day on top of excess emissions fees. Fourth, Mr. Johnson has testified, and the board has evidence before it, that closing the facility and stopping operations would not result in a corresponding benefit in terms of reducing air contaminants, particularly because shutting down might result in power being supplied by less efficient or less clean methods in the event of a grid power failure during unexpected energy demand surges. Fifth, the board has evidence before it that SoCalGas considered curtailing operation of the 3 compressor engines at Playa del Rey, but that curtailment would not be feasible. Sixth, Mr. Johnson has testified, and the board has our evidence that during the variance period, if a variance is approved, SoCalGas will reduce excess emissions to the maximum extent feasible. And finally, Mr. Johnson has also testified, and our petition sets forth that during the period a variance is in effect, SoCalGas will monitor or otherwise quantify and report its emissions levels from the 3 engines if the district requests. So to sum up and reiterate, SoCalGas now respectfully requests a variance from the 11 ppm NOx limit under Rules 1100 D3, 1110.2 E10, and permit condition 195.5 of its permit to construct. And we request that variance only through the end of February 2026, with the 3 engines becoming subject to the approved compliance plan once the retrofitted engines are installed and operational. And with that, we thank the board members again for considering our request, and we express our thank you again to district staff as well.
Thank you, Ms. Pruitt.
Thank you, members of the board, Mr. Chair. The district appreciates the collaborative efforts made by the petitioner and recognizes the constraints involved. Based on the record before you and the mutual understanding that compliance can be achieved under the original petition and its conditions, the district respectfully reiterates that it does not oppose the relief sought. Thank you.
Members of the hearing board on deliberation, Ms. Verdugo-Peralta.
Thank you, Mr. Chair. I am in agreement that a variance should be granted based on the fact that they have worked diligently with the district to make sure that they were going to be able to meet the dates proposed for the 11 ppm, and the fact that they are vital to the grid in reference to the storage facility and the way that it's going to be utilized. I think that there would be no other option but to grant the variance. Thank you.
Any additional comments, Mr. Bellicopoulon?
Yes, I'm going to oppose it only for the, not, if they had not got the compliance plan, which, and had come for the variance from the rule limit, I would say, yes, they met all the conditions, the 6 findings necessary. I'm at a loss, actually, why the district would issue a compliance plan, which is a path for the compliance, knowing when they will violate it when it's issued. That, and there's provision in the rule, and I'll just, since I couldn't bring this in the questioning, but I'll in the staff report, I remember reading it and went back to it. The amount for the fee for mitigation is expected to be approximately the amount of that the facility would have to pay to go through the variance process, including excess emission fee, notification procedure fee. I think the intent at that time is the compliance plan provides an avenue so you don't have to come before us. And it's my understanding, and because there is provision to modify, what you call the revised plan, to issue a compliance plan, which puts you out of compliance right away. That doesn't make sense to me. For that reason, only I'm going to say vote no.
Any additional comments?
Just to be clear, this is stipulated conditions, so that makes it easier in terms of our support to find the 6 findings.
Yes, and we commence May 15th through May 18th through February 28th.
Correct. 2026.
Perfect. All right, good deal. Okay, in the matter of Southern California Gas Company, case number 137-82, facility ID number 8582, I move that we grant a variance commencing May 18th, 2025 through February 20th, 2026 from the following rules, permits, address locations, which are all encased and set forth in Exhibit A. In addition, payments and final compliance details are also encased in Exhibit A. Is there a second?
I second.
Second by Ms. Verdugo Peralta. Any further question or discussion here? Now, Dr. Abraham?
Aye.
Ms. Verdugo Peralta?
Aye.
Mr. Balakapalan?
No.
Mr. Pearman? Aye. Ali votes in the affirmative. The matter is approved 4-1. You guys have a phenomenal morning. We're off the record at 10:48 a.m. And by the and just for the record's sake, we did post. I was going to be remote. It's on the agenda. However, we didn't post the agenda at the location in Compton. However, the hearing is still being broadcasted via the office as well as Zoom. So if anyone from the public elected to go to the address on the agenda, they would be able to view the meeting. Just wanted to place that on the record. I believe the excess emissions,
The second page that she gave you.
yeah, but I thought they were,
Second page you gave.
okay.
Well, he incorporated.
Yeah, I incorporated the excess emissions and what have you within the exhibits. Or you want me just, well, I don't mind calling it out. Okay, just for the record. The excess emissions. Yeah, NOx access EF-828.48 pounds. Correct?
Sorry. Sorry.
That's the outdated one. There's another one that has been updated.
I'm a thief.
It's 871.07 pounds.
Yes, okay, so, yeah, and that's actually in, yes,
Sorry.
so that's incorporated in the exhibit. The NOx, it's all incorporated in the exhibit.
That's not the excess emission, that's the emission factor. The excess emission is the difference between that number that Ms. Pruitt cited and the baseline, so that's approximate, if you like, I think it's probably was listed in the compliance plan, in the approximately,
Okay.
the difference is about, that's the month, so about 45.82 pounds per day approximately for NOx.
Is that what we have, Ms. Pruitt? No, go right ahead, go right ahead. This is a collegial and collaborative meeting.
And that's in the that's in the revised, petition that was submitted on page, attachment, number 19, in the revised, proposed revised petition.
Which we withdrew.
Yeah, but the numbers are there, that's what I'm saying, approximate, so I'm referring to that for the numbers.
But Mr. Vogel and company, did the numbers change from the previously submitted petition? So the numbers are not what Mr. Palaka-Palan are stating?
Are we using a different thing?
We're using, if you look at the conditions, the numbers change that. It's like more accurate numbers.
And I think we're talking about the baseline.
Change things.
Is the baseline the question?
No, it was just pretty much the excess emissions.
The T4 that they already have.
I think the original variance petition has an estimate. Page-
Page 7 of the petition. So is that,
And that.
Oh,
And if I may, we don't have the emissions because they have to accumulate usage. And we have the numbers, the emission factor here for on number 2, and based off of 225 ppm. And so it's not possible at this point to have the emissions. Yes, so it will be determined.
okay, so is the record clear, Madam Clerk? Okay. All right, folks, today's hearing is adjourned at 10:52 a.m. and we're off the record. Hold on one second. Are we good, Vogel? Because everybody's looking around.
Do we want to speak to the 54.48?
What, no, no, it's fine, it's fine. All right, folks, we're completely off the record on the adjourn. You guys have a phenomenal